Hello, this is Professor Budwell, and in this video, I'm going to talk a little bit about the legal research process. It is important to note that while some of the questions posed in your homework assignments may be answered in this video, it is not intended to take the place of your readings, so please be sure to go through those thoroughly. Now, whenever you are conducting legal research, your goal is to find the law. Now, that may sound simple, but it really isn't. When you are conducting legal research, you want to make sure that you are considering both the cost and the content of what you are researching. When you're considering the cost, you have to remember that your client may have very limited resources and that you have duties to other clients as well, and you do not want to neglect those. When you are considering the content, it's very important to remember that not all authority is the same. Let's break that down a little bit. Whenever you are conducting legal research, you're going to be looking at both primary and secondary authorities. Primary authorities are the actual law, whereas secondary authorities explain the law or help you find the law. Here are some examples of primary authorities: constitutions, statutes, and case law. Now, these are some examples of secondary authorities. You have legal encyclopedias, which tend to be more of a general overview of the law, treatises, which focus more on a specific area of the law, American law reports, which are also very narrowly focused. They have very detailed articles about narrow points of the law, restatements, which can show you model laws and commentary on those laws, practice guides, which can be very helpful if you practice in a specific field like I do. I practice in the area of bankruptcy. And you also have law review journals. Now, one last comment about law review journals. They tend to be much more theoretical, so you might have commentary on what the law should be. You will often get a very good analysis of, for example, a certain Supreme Court case, but remember that these do tend to be much more theoretical than statements on what the law actually is. So we've just gone through some examples of primary authorities versus secondary authorities. Now let's take a look at the weight that these authorities might have when you're in court. Again, not all authority is the same. You have mandatory authority, and this is authority that the court must follow. And on the other hand, you have persuasive authority. Let's break those down a little bit. Here are some examples of mandatory authority, and it's important to note that whenever you have a mandatory authority, it will always be a primary authority. So the Constitution is a good example of a mandatory authority, and that would be the Constitution of the United States. State constitutions are mandatory in the states where you're practicing in, as long as it's the same constitution for that state. Federal and state statutes, decisions of the United States Supreme Court, decisions from a state Supreme Court in that state, and decisions from federal or state courts of appeal. And that's within the same jurisdiction, obviously. And these are some examples of some persuasive authorities. Now, it's important to note that persuasive authorities can be both primary and secondary authorities. So remember earlier, we talked about how judicial opinions, case law, are a primary authority, but they are not necessarily a mandatory authority. So if I'm arguing a case in Virginia and I have a piece of case law from the state of Colorado, let's say from the Colorado Supreme Court, that is a primary authority, but it is not a mandatory authority. So it may be very persuasive, but it is not necessarily going to be followed by the court that I'm arguing in Virginia. Secondary sources are a great example of persuasive authorities. You're not always going to see those used in arguments in court because, like I said, it's usually the case with secondary sources that you want to use those to help you find the law, so to help you find primary sources. But it is interesting to note that a secondary source can become a primary source if a judge adopts the reasoning from a secondary source. So let's give an example of that. Let's say I'm arguing a case in the Virginia Supreme Court, and I haven't found any case law or other primary source that's particularly on point. But I bring something from a secondary source that I think summarizes my argument very well. And the court agrees with me, and they adopt that in their opinion. That aspect that I have argued has now become a primary source of law. Now, you probably won't ever find a situation where a court adopts an entire secondary authority. So you will probably not see a court adopt the entire restatement of torts, for example. But it's very common that they can adopt certain portions of it. Now, another great example of a persuasive authority are judicial opinions from the same court. So sometimes opinions from like a state trial court in Virginia, that would be the circuit court, are published. Now, it's interesting to note that those opinions are not binding on the same court. So circuit courts in Virginia have quite a few judges in them. So let's say I'm arguing a case in a Virginia circuit court, and I found an opinion from a Virginia circuit court. Let's say I'm arguing here in Virginia Beach, where I practice, and I find an opinion from a circuit court in Richmond. Now, it's important to note that that's not a mandatory authority on a circuit court judge here in Virginia Beach. But a circuit court judge in Virginia Beach will be very unlikely to disagree with his colleagues. So that can be a very persuasive authority. Now, a good roadmap whenever you are conducting legal research is to start with a secondary source because they might explain the law a little bit better and maybe a little more thoroughly than something you might find in a primary source. So, for example, a primary source can be a statute, but the statute doesn't always give you a lot of guidance on how it applies to certain situations. You might find in a secondary source, say a treatise or a restatement, some good commentary or examples of case law where certain facts applied that law, and that might help you a lot in making your argument and lead you to some good primary sources. So that is a very basic summary of the legal research process and some of the resources that you'll have at your fingertips when conducting legal research. But be sure to thoroughly review the readings, your CALI assignments, as those contain much more detail. And please reach out to me if you have any questions.